Okay, good afternoon, Amma. Only one session for Saturday, right? 2 to 4. Very good. So, next morning class unda meeku. Huh? Okay. Right. Meer both kada. Role of RBI. Oh, no, not applicable for you. Our previous discussion relates to directors and KMP, right? So, classification of directors completed. Yes, rotation. Appointment, reappointment, rotation also completed. Rotation calculation we have discussed. So, if any fraction came, how to consider? In some cases, we have to consider next number. In some other cases, we have to consider nearest number. Okay. So, 6 only. Nearest, 5. Nearest aithe. Above 5 only, we have to consider next one. Okay. One more point is also there for you, right? 188, yes. Okay. ఇప్పుడు గుర్తుంది. I mean, అంటే కంటిన్యూస్గా స్కిప్ అయిపోతుంది అది. సో one point needs to be highlighted, ma. So what is that point means? In our disqualification 164, disqualification is there, no? Section 164, 3 levels of disqualification is there: personal disqualification, individual level disqualification, company level disqualification, disqualifications mentioned in AOA, articles of association. So in that 164, one point is there: conviction under section 188. So what exactly the point is? So if you need clarity with respect to this point, first of all you have to know what is meant by conviction. Conviction means, in lot of Telugu movie climax scenes, judge will announce the judgment. Under section so and so, hero is convicted. So that means, if court believes that, slowly follow, if court believes that you did a mistake or you did an offense or you did a wrongful thing under so and so section, forget about imprisonment. If court believes that you did a mistake or you committed a faulty thing, okay, then you are a convicted person. Forget about imprisonment. Why? Because for your conviction, court may award imprisonment, or court may award monetary penalty, or court may award both. In some cases, what judges will do? They will do both. They will do award both monetary punishment as well as imprisonment. Both will be awarded. So forget about punishment. How the punishment is going to be? Is it going to be restricted until only for money or any imprisonment? Forget about imprisonment, monetary penalty, nothing. From the date where you convicted under section 188, what section 188 is saying? Related party transactions. So from the date, 5 years disqualified. From the date, 5 years disqualified. This is all about section 164 subsection 1 clause G. Section 164 subsection 1 clause G. That clause G is exclusively applicable to this related party transaction conviction and all. Okay, so come again. So section 164 talks about disqualifications of director. 164.1 talks about individual disqualification. 164.2 talks about company level disqualification. 164.3 talks about disqualifications or any additional conditions imposed under AOA, articles of association. In this 164.1, clauses are there: A, B, C, D, unsound mind, imprisonment, insolvency, like that. One clause is there, that is G. It is saying that if a person is convicted under section 188, from that conviction date he is disqualified for 5 years. From that conviction date he is disqualified for how much period? 5 years from that conviction date. Now students will ask, say for example, today 29th, 30th, 30 August 2025. Yes, sir, today court declared that so and so X committed an offense under section 188 and court convicted him with monetary penalty 1000 rupee, imprisonment 1 year. Then 5 years we have to calculate from release data, starting data. Forget about release date and starting date. If he is going under imprisonment for a period of 1 year, do you know, less than 6 months, no disqualification. 6 months to 1 year. From the release date, 5 years disqualification. That provision will be attracted. That provision will be attracted. Okay, say for example, today, 30 August 2025, Mr. X declared as a convicted person who committed offense under section 188, related party transaction. And listen, what 164(1)(g) is saying, if you committed any offense under related party transaction, 5 years disqualified. How much time? 5 years disqualified. Now, few students will ask, sir, say for example, 6 years imprisonment given, sir. Judge gave how much imprisonment? 6 years imprisonment. And you are saying that only 5 years disqualified. That means extra 1 year he is in jail, no? So, can we appoint that kind of person as director to our company? Why to refer 164(1)(g)? In 164(1), there is a clause. What that clause is saying? If imprisonment period is exceeding 6 months and up to 7 years, from the release date he is disqualified for how many years? 5 years. That provisions are applicable. No need to confuse. If the person is going for imprisonment, 164(1) takes care about of his disqualification. Clear? In 164(1)(g), related party transaction, that means section 188. If you committed any offense under section 188, related party transaction, always do remember one point. What is that one point is? From the declared date. Sir, what is declaration date? Court will declare you as a convicted person, no? So, from that declared date, 5 years you are disqualified. From the declared date, how many years you are disqualified? 5 years you are disqualified to act as a director in any company. That is what 164(1)(g) is saying. That is why, in order to properly understand this 188 related party offense, first of all, you have to know one point. What is meant by conviction? What is meant by conviction? Conviction may be in monetary penalty, conviction may be imprisonment. There is no hard and fast rule that conviction means imprisonment only. There is no hard and fast rule. Say for example, without helmet, challan imposed on your bike, you are a convicted person. You are a convicted person. That means you along with your bike or car are going to jail. No, you are a convicted person means you can escape by paying monetary penalty. Baita. Beyond our control. Okay. So, that is what 188. Are we clear? Okay. Related party transaction. Meer adigin doubt idega? Deni gurinchega? Okay, right. So, back to our topic. Which chapter we are discussing? Directors and KMP. Directors and KMP. In that chapter, first of all, we are discussing directors. Director, who is director? Section 234. He is a person who is appointed to the board of the company. So, role of director, minimum number, maximum number, classification of director and all we have discussed. After that, appointment, reappointment, rotation discussed. Appointment of first director. Do you know the concept of appointment of first director? Tell me. In order to appoint first directors, whether they are appointed or not, always refer AOA. Yes, sir. AOA mentioned the mechanism with respect to first directors. AOA is representing first directors. Okay, no problem. Those persons will act as first directors. Sir, AOA is silent, sir. All individual subscribers who are acting as subscribers to the company, where you can find this list? MOA, which clause? Association clause of MOA. How many clauses will be there in MOA? 6 clauses, 7 clauses. NROCLA, 6 clauses. N for name clause, R for registered office clause or situation clause. Registered office clause or situation clause. O for objects clause. C for capital clause. L for liability clause. A for association clause. Association clause. One guy used to be there where he is not came. I don't know the name of the person. He used to sit here. That bad fellow. ఏం పేరు? నితిన్. ఓకే, రైట్, రాలేదు. కంటిన్యూ. What we are discussing? This is the mechanism for first director's appointment. Second one, subsequent directors. Tell me, how you will appoint subsequent directors? Actually, in private companies, freedom has been given for private companies to follow their own set of rules for the appointment of second and subsequent directors. When it comes to public company, tell me, when it comes to public company, directors appointment must be made by shareholders in general meeting. Which general meeting? AGM only. AGM only. General meeting means obviously AGM, right? No. No, general meeting means it may be AGM or EGM. Emergency general meeting. Emergency general meeting. Extraordinary general meeting. Okay. So don't derive your own definitions for the nomenclature. So obviously we'll end up in confusion. So next one, after AGM, EGM, OPC. Tell me OPC. OPC first director is very funny. Why? Because the person who is starting the company, obviously he will become first director of the company. Second and subsequent directors will be taken care of that by that person. No need to conduct any AGM. Only one person is there. Completed. Rotation. Tell me, rotation norms applicable for public companies or private companies? Only for public companies. Only for public companies. Actually, there are lot of relaxations with respect to these procedural aspects. When compared to public company, private company is enjoying lot of relaxations. Sir, what kind of relaxation? This kind of reappointment rotation mechanism is there, no? Rotation mechanism is not applicable to private companies. That means no need to retire directors by rotation mechanism and all. Private companies not applicable. Second one, consent form is there, no? Do you know about consent? DIR 2. DIR 2. DIR 1. Discontinued. DIR 3. Application to MCA to obtain PAN number. Oh, PAN, DIN, both are same. Both are 8 digits only, no? C, D, V, P, B, 5, 7, 4, 2, E. 10 digits PAN number. Okay. So, DIN 8 digits. Okay, so DIR 3 application, DIR 2 is consent. So, in public company, every director has to give consent. Yes, I am ready and willing to act as a director in your company if your shareholders appointed me as a director. This is the case. But this kind of consent is not applicable in case of private company. No need to give consent. Internal consent is enough. Internal consent is enough. Where in case of public company, director has to give consent and this company personnel has to submit the same to their husband. Who is their husband? Obviously ROC, registrar of companies. Everything will be taken care of that guy only. Okay. Second husband is also there, RD, regional director. So he is a guest faculty. Okay. Major things will be taken care of by ROC only. He is the administrator who is responsible for the proper administration of the company. Okay. Beside all these things, we are talking about relaxations, right? And 1 lakh relaxation is also there. I think I have already communicated this point. If you wish to participate as a if you participate in the election of director, security deposit you have to deposit with the company, minimum 1 lakh deposit. That kind of deposit mechanism is not there in case of private company. It is there in case of public company. Rotation mechanism is not there. Participation 1 lakh, 1 lakh security deposit mechanism is not there. Filing individual consent is not there. And one more thing is there, no? In case of public company, you have to appoint board of directors. For each board of directors appointment, you have to pass each resolution. Individual resolutions are required for the appointment of directors in case of public company. Whereas in case of private company, there is no necessity for individual resolutions. All board of directors can be appointed by passing a single resolution. Can private company have 10 directors? ఎందుకు ఆలోచిస్తున్నారు? 10 ఉండకూడదా? Minimum number how much? Minimum 15, huh? Minimum for a private company how much? Minimum to maximum 15. Maximum 15 for any company, OPC, private, public. Beyond 15 also allowed, but special resolution required. So listen, if a private company wishes to have 10 directors in their board, okay, go ahead, no problem. For all these 10 directors appointment, they can appoint 10 directors to the board by passing a single resolution. Single resolution. Enough. But in case of public company, for each director, you have to pass one resolution. So the lot of relaxations are there. I shared few relaxations with respect to public company and private company comparison. Okay, no need to write and all. Why? Because it is not there in your syllabus, but out of for knowledge purpose, we are sharing the points and all. Okay. Next, what we have discussed, rotation. Rotation, tell me, in rotation calculation, what kind of directors we have to exclude? Independent director we have to exclude. Nominee director we have to exclude. Small shareholder directors we have to exclude. Additional and alternative director also we have to exclude. Why you are excluding additional director and alternative director? Why? Because appointment of additional director and alternative director done by board, not by members. Members, shareholders, both are same. So not by members. That is why you can exclude ADs, additional director, alternative director from the calculation. Okay, sir, we have excluded ID, independent director, nominee director, small shareholder director, additional director, alternative director. Some number will come. On that number, apply 2/3. So rotational directors 2/3. Okay. So minimum that number or maximum numbers you have to appoint that much strength as rotational director. Out of the rotational directors, 1/3 calculation. In this 1/3 calculation, you won't consider next number, you will consider nearest number. That is the thing. Okay. So next what we have discussed? Deemed appointment of retirement directors. Okay. If 4 conditions satisfied, he's talking about this point, this one. I have already explained this point. If nothing is stated expressively in the meeting saying that in the place of so and so director, outgoing director, this person we are appointing, nothing like that has been taken care in that general meeting, then obviously retiring director will act as a director in the company. No need to go out of the company. Okay. So rotation also done. In rotation, these many directors we are not including, and whatever the number came, this is one of the point. Managing director or whole time director. Are we going to include this MD or whole-time director, WTD, in this calculation? Depends. There is no straightforward answer. Neither yes nor no. Depends. Sir, depends on what? Depends on their agreement. Depends on their agreement. Say for example, listen, you have to be fundamentally strong. First of all, understand the process. Whenever a company is appointing MD for the MD of the company, or whenever a company is appointing a WTD to their company, MD, WTD. MD means managing director, WTD whole time director. Listen, in Companies Act, there is no strict and stringent rules saying that MD must be MD must be the director of the company, or MD must have place in the board of the company. There is no hard and fast rule. That means a company can recruit MD as an employee. I repeat, a company can recruit MD as an employee. Tell me, who is MD? MD is a person who is going to have substantial powers of the company. Is he going to involve in the day-to-day affairs of the company? Obviously yes. Why? Because he is the substantial powerhouse. Okay, so managing director is one of the crucial person in the entire company. Whole-time director, he is a dedicated one. Obviously he is an employee. So listen, MD or WTD depends on their nature. Sir, what nature? Listen, say for example, I have a company. I need one MD and one WTD, one managing director and one whole-time director. I can recruit one MD, one WTD just as an employee. There is a facility for me. For me means, who am I? I'm a company. I'm a company. I'm recruiting MD and WTD as employees of the company. That means I am not going to offer directorship to those two persons. I'm not going to offer directorship to those two persons. I'm just offering what? Employment. I'm just offering employment. It is possible. It is 101% possible. There is a rule in Companies Act. No need to offer directorship for MD and WTD. In general, by default, what will happen? MD is a director of the company. WTD is a director of the company. Unless otherwise stated specifically, MD will act as a director of the company. WTD will act as a director of the company, obviously, unless otherwise stated. But no, sir, I don't want to involve MD and WTD to this mechanism. I don't want to involve them. I just want to recruit them as an employee, sir. Is there any facilitating provision providing for this facility in Companies Act 2013? Means yes, there is a provision. You might ask, sir, why this kind of provisions are made? Listen. Obviously, in today's scenario, in reality, elections depends upon favorism only. That favorism may be caste basis, region basis, religion basis, or whatever basis it may be. Say for example, I'm the chairman of the company. You all are shareholders of the company. Who are the real owners of the company? Obviously you. Obviously you. I too have some sort of shareholding in the company, but majority of the shareholding vests with the general public only. Are you following? Okay, who are you? Who am I? Chairman. Okay, baane undi vinnaniki. Okay, right. What is this? This is a general meeting. Okay, listen ma. In the best interest of the company, I have recruited one skillful person as MD and 3 more persons as whole-time directors. Totally, I have recruited 4 members, MD, WTD, 1 managing director, 3 whole-time directors. These 4 guys are well-dedicated persons. They are investing their blood and sweat for the growth of this company. And after 3 years, yes, 3 years passed, and company, we are witnessing profits. All these years we are suffering with financial difficulties and losses, and now all our accumulated losses have been wiped off and we are running in profitable scenario. Due to whose person's talent and skill ma? MD and 3 whole-time directors. Very good. Listen. Say for example, consistency is the key. So listen, what might have happened if I recruit these 4 persons as directors of this company? That means I am offering employment as well as directorship to these 4 persons, 1 MD, 3 whole-time directors. Then what will happen for this MD and for this for the remaining 3 whole-time directors? They will be included in this rotation mechanism. 2/3 shit, 1/3 shit is there, no? Every year what they have to do? There is no guarantee that after the closure of this meeting, there is no guarantee that whether he will be continuing with the company or not. No guarantee. Why? Because it all depends upon your hands. You may elect him or you may not elect him. But deep down, he is investing his blood and sweat for the growth of this company, but where you are not recognizing his efforts. You are simply casting your vote, depends upon your favoritism basis, region, religion, caste, creed, whatever the basis it may be. You are not recognizing the talent and skill. You are making favorism here. Then what will happen? These kind of skillful persons are there, no? The company will forego the services of this skillful person. Obviously, at whose loss? Who will be losing if the 4 persons leave the company? Obviously, company is going to suffer. That is why, listen, that is why if management is in a opinion that, if management is in a opinion that, MD or WTD, if you remember, I will show you. I have clearly written this point in your material. Kindly read this, MD. MD means a director who is entrusted with substantial powers of the management of the company affairs. Just now I told that unless otherwise stated, MD is a director. Okay, next one, whole-time director. A whole-time director is a very, very important full-time employee of the company and is entrusted with regular duties like executive directors, but he is subordinate to the board and MD if appointed and required to devote whole working time to the company. That means this MD and WTD are investing their 100% of time for the growth of this company. Avuna? But what we are doing? We are including them into this rotational sheet and retirement sheet, and there is no guarantee or warranty that, say for example, one director is thinking to develop the company down the line 4 to 5 years growth plan he is decided to implement in the company. 4 years growth plan. After 1 year, his employment gone. Why? Because we didn't elected him in the rotation process. We just left him. Just like KKR management left Shreyas Iyer, no? Even after giving the IPL Cup and all. So, just like we also left that MD where he is investing his 100% of time and efforts for the growth of our company. But we didn't elected him for the upcoming, board composition. Then will he get demotivation or not? 101% he will be demotivated, obviously. So that is why, in order to remove this kind of unnecessary mess in the management, there is another process or another option. What is that option? Means, sir, I am recruiting some skillful persons for the growth of my company, for the growth of our company, not my company, growth of our company. But I wish to keep them far away from this election process. Is it possible? Yes, possible. We can recruit managing director and whole-time director as employees of the company. Then what will happen? They don't take any part in the board of the company. They are not even directors. Being they are not directors, no need to participate in election process, rotation process, retirement process. In this way, I can secure the position of these 4 persons. Who are 4 persons? 1 managing director, 3 whole-time directors. Is it clear? In this way, I can secure the skill within the company. Clear? So that is why whether MD or WTD is going to participate in rotation or not depends. There are no straightforward answers. Neither yes nor no. Depends, sir. Depends upon their recruitment process. Depend upon their agreement. I'll show you. This point also I have written. Appointment, reappointment, rotation process. No, we are studying. Yes, this rotation process. Yes. Kindly read the highlighted point. Managing directors and whole-time directors can be included in the rotational pool unless their appointment terms exempt them. Are we clear? So, do you understand the logic? So, why company is putting away these MD and WTD from the selection sheet and all? So, there are certain reasons with respect to administration of the company. Okay, next. So, these are the topics we have discussed. Next one, resignation and removal. Did we completed this discussion also? No? Resignation not completed. DAR 12, DAR 11. చెప్పాను కదరా లేదా చెప్తా అన్నానా చెప్పలేదా ఓకే చెప్పలేదంటే చెప్తానులే సో రెసిగ్నేషన్ అండ్ రిమూవల్ మా సో కైండ్లీ లిజన్ we are going to complete resignation and removal process in this session. So first of all, we are talking about resignation. First of all, we are talking about resignation. Sir, what is meant by resignation? Simply, resignation is a voluntary decision taken by an employee for not to continue with the employer. Simple. So resignation is a voluntary activity. Okay, there is an option for director to take exit from the company by simply serving a resignation notice to the company. There is a way. Removal means it is a different way. Shareholders are removing the director even before the term, even before the expiry of the original recruited appointed term. Whereas resignation also early exit only, but it is a voluntary activity initiated by the so-called director. Okay, so very simple ma. Resignation at any point of time, director may serve resignation to the company at any point. Okay, but reason must be mentioned. That is the only thing. Why? Because if you are going out of the company without mentioning the reasons and all, it will create unnecessary confusion among the investors. It may defeat the spirit of investing in the company, or it may create loss of confidence among the investors with respect to the administration of the company. That is why you have to mention the reason of resignation. Yes, you are allowed to take exit from the company by simply serving a resignation notice, but you are under an obligation to mention the reason. Generally in reality, everybody will mention, almost in majority cases, personal reason. Personal reason means no need to specify. It is your personal. Why to specify? No need to specify. Due to personal reasons, I am taking exit from the company. This is my resignation letter. Done. Close. Or if you are facing any maltreatment within the company, or any discrimination kind of thing, or if you are not liking something, you have to communicate through your resignation notice. It's up to you whether you are going to communicate or not. It is up to you. Sir, what is the date of resignation? Simple thing, ma. If you mentioned anything, any specific date in your resignation letter, from that date you will be treated as resigned from the company. Sir, nothing is mentioned there. They just served the notice. No specific date has been mentioned. Then how to treat? the date of serving the notice will be treated as date of resignation. Date of resignation. And one more thing, whenever a director resigned from the company, it is the responsibility of the company to intimate ROC via form DIR 12, DIR 12, new form number DIR 12 within 30 days. Within how many days, ma? Within 30 days, company has to inform to ROC saying that so and so director left our company. And with respect to this DIR 12, you are going to continuously hear about this DIR 12. Why? Because, listen, why? Because whatever change happened to the composition of the BOD to your company, sir, new appointment done, okay, change in composition. Existing director died, change in composition. Okay, resigned, removed, everything, anything, disqualified, anything. So if any change happened to the composition of board of directors of the company, then it is a responsibility of the company to intimate ROC within 30 days via form DIR 12. DIR 12 is so famous in reality. DIR 12 is very famous. Company has to intimate to ROC with respect to the change or change happened with respect to their BOD of the company. That is one thing. And listen, who is going out of the company? Director, right? So it is a responsibility of the director to intimate ROC via form DIR 11. DIR 12 applicable to company, ma. DIR 11 applicable to outgoing director. So, sir, is filing form DIR 11 is mandatory? No, optional. But filing DIR 12 is mandatory. Say for example, you are filing DIR 11 and company is filing DIR 12. Okay, no problem. Sir, isn't it amount to duplication of information? What will happen? Everybody is communicating the same to ROC. No concept of duplication and all. So DIR 12 is a mandatory thing which a company need to comply. Mandatory thing, no option. Company has to intimate within 30 days. Otherwise, penalties will be imposed on the officer in default. Where in case of DIR 11, it is not a mandatory thing. It is up to the choice of the director. It is up to the choice of the director whether is he going to intimate to ROC about his resignation or not. Depends upon the choice of the director. It is optional. Sir, DIR 11 didn't filed by director, sir. Okay, why? Because it is optional. That's why he considered it as a light form and didn't intimate it to ROC, sir. And company also didn't inform to ROC, sir. Within 30 days, even after exceeding 30 days also, company failed to inform ROC with respect to the change happened within the constitution of the directorship, BOD. Okay. Now what will happen, sir? In ROC mind, from ROC point of view, this resigned director is continuing with the company and he continues to be liable for the acts done by the company even after his resignation. Until you properly communicate to ROC saying that Mahaprabhu, nenu bayatiki vellipoyanu, I am not related with the company. I have taken a soft exit from the company. This is so and so form. I am not responsible for the activities done by the company. Until and unless you formally communicate to ROC about your resignation, you will be liable. Why? Because of course DIR 11 is optional, ma. But is there any guarantee that company is going to file DIR 12? Is there any guarantee? Say for example, sir, you said that officer in default is liable. Okay, liable. How much penalty? 1 lakh rupayalu ra. Okay, 1 lakh. He is ready and willing to pay. He is ready and willing to pay. So some people will be like this only, no? Magadira villain type. Naku dakkandi. Evarki dakkakudadu. So say for example, hardly this MCA mechanism, Companies Act will impose 1 lakh or 2 lakh penalty. This guy, officer in default, is ready to pay the penalty. But he wished to trouble that outgoing director. Just after the exit happened with respect to the director in the name of resignation and all, company borrowed 50 lakhs or 1 crore or 5 crores from a bank or public financial institution and intentionally defaulted in the payment. Then who are liable? Along with the existing directors, that guy is also liable. Sir, these guys are suffering. Okay, no problem. They can suffer. They are suffering. They are very happy. Why? Because they are suffering this outgoing director. Okay, don't take external politics in a light way, ma. Okay, these kind of things are not at all abnormal. Very, very normal. People will be like this only. Okay, so nobody will be like Relangi Mavaya. మనిషి అంటేనే మంచోడురా, పొద్దున్నే న్యూస్ పేపర్ చదువుకుంటూ బ్యాక్గ్రౌండ్ మ్యూజిక్లో ఇద్దరు స్కూల్ పిల్లలు సైకిల్ తొక్కుంటూ స్కూల్కి వెళ్తుంటే వెనక నుంచి సైకిల్ని నో, అవసరమైతే ఆ సైకిల్ని పొలాల్లోకి నెట్టేస్తాడు తప్ప హెల్ప్ చేయరు. సో విచ్ ఈస్ ద prudent scenario, which is the better scenario? Just after resigned from the company, it is advisable for your skin to inform to ROC by filing a form called DIR11. Sir, it is an optional thing. Array, kindly listen to me. File the form DIR11 to ROC and intimate to ROC saying that you and company are not related. It's for your good only. Okay, so it is better. Of course, company is also having responsibility to intimate via form DIR12 within 30 days. Which is optional? DIR12. Very good. 11 or 12? 12. 11. 11 will be filed by company. Very good. 11 will be filed by director who resigned. Outgoing director. Very good. 12. Company. Okay, so that's it. Nothing more about resignation and all. Okay, let's read the material. Resignation of director, section 168. Section 168. Next one, removal will come 169. So resignation 168. A director may voluntarily resign from the board of the company. The law lays down a clear process for such resignation. What is the process? The director must means you have to follow the process. Okay, must submit a written notice of resignation to the company and can be submitted to the board or CS if any. Say for example, board members are not available, if CS is there, you can submit the resignation to CS. Sir, will CS accept, sir? You are intimating, not asking the permission. You are just intimating that, Are Babu, I am taking exit from the company. That's it. You are not asking the approval of the person. CSR, Elipotan sir, Elipomantara sir. You are not asking the approval. You are just intimating. So it is your decision, not CS decision or board of directors decision. Why? Because you are the director. It is according to your will and wish whether you are going to continue with the company or you are going to take safe exit from the company. No one can dictate you. Aham Brahmasmi. Okay. Next one. So the resignation becomes effective either from the date specified in the notice. If anything is specified in the notice, from the date resignation will come into effect, or from the date on which the notice is received by the company, whichever is later. Sir, nothing is mentioned in the resignation letter, sir. Nothing is mentioned in the resignation letter. Then the date of receival. Out of these two dates, whichever is later. Some smart fellows, what they will do, say for example, today they are having some issues with the director, board of directors. Today's date is 30 August 2025. Sir, I am resigning from 1st August 2025, sir. 1st August 2025. Is it possible? All these days you acted as a director for the company, and to simply escape the responsibilities and all, you are mentioning a earlier date. How it is possible? Don't think that you are the only smartest person in the room. Okay, so mentioning earlier date is not possible. Okay, so if you don't like the company's behavior or board of directors behavior, okay, you can take the exit from the company. Okay, but from today or tomorrow or day after, it should be on futuristic basis or on immediate basis, not on past basis. Not on past basis. Okay, so now 30th August you are having issue. I am taking exit from the company from 1st August. If they mention like this, what will happen from 1st August to 30th August? He is escaping the responsibilities. But in reality, he continued with the company. For 1st to 30 August, he continued with the company. But simply to escape the responsibilities, what he is mentioning? He is mentioning a earlier date. It is not possible. That is why lawmaker is very clear about his intention, and this date or this date, whichever is later, even though you smartly mentioned 1st August. This is the date mentioned in the resignation notice. On which day you are submitting your resignation letter? 30 August. 30th August. 1st August or 30th August, whichever is, which letter? Obviously 1st August is later. 1st or 30? 30th August is later. That is why from that date resignation will become effective. Okay. Next one, obligations of the company. I have already communicated this. Obligations exist for the company as well as obligations there for resignation director also. DIR 12, DIR 11. Okay. Listen, the company must take note of this resignation in the next board meeting. The company must file DIR 12 form with ROC within 30 days from the date of resignation become effective. The resignation must be disclosed in the next board report, annual financial statement. With financial statements, you are going to attach board report, right? In that board report, you have to mention so and so director appointed by you. You means members. Appointed by members resigned from the company. Transparency norms. Okay, you have to mention the same thing in the board report. And this board report obviously going to attach with financial statements of the company. Very good. What are the obligations of resigning director? What is this? Optional, but recommended. For the best benefit of resignation director, it is recommended, but of course it is optional. What is this? The resigning director may also, may, not must, may also forward a copy of the resignation along with the reasons. Along with, I have already told this point, you have to mention the reasons. Okay. So if you don't want to mention the exact reason, personal reason also, not a problem. So along with the reasons to ROC in the form, same form is changing, that's it. Okay. However, DIR 11 is optional for the directors of the private companies as per MCA notification dated 5th June 2015. Anyone? Okay. Next one, liabilities post resignation. Resigning director shall remain liable for the offenses or liabilities incurred during his tenure as a director. Offenses or liabilities occurred during his tenure. Okay. Resignation does not absolve past responsibilities. Absolve means release. Absolve means what, release. So just because you resigned from the company, you are not released from the liabilities or offenses which are committed under your tenure. Okay. So resignation does not absolve past responsibilities or statutory breaches during his office. For whatever the offenses committed during your tenure, along with other directors, you are also equally responsible for the offenses. Next one, special case, resignation in case of OPC. There is a possibility that in OPC, maybe only one director may be there, no? Of course, 15 also allowed, 20 also allowed, but there is a case that only one director is there in the OPC. Why? Because according to Companies Act provisions, minimum number of directors to have by OPC, how much? One director. So say for example OPC is there, one director. The director, by simply serving resignation, he is going out of the company. Then that OPC will become driverless car. Simply that there is no one to show the directions to the car, to the company. Then what will happen? That is why lawmaker clearly made a responsibility on the sole director, saying that, Babu, the sole director can resign. You can go out of the office, no problem. But only after appointing another individual as the director. You can go out of the car, no problem. Appoint someone as a driver. Okay, so the sole director can resign only after appointing another individual as the director and intimating the same to ROC. Then he may take leave from the company. This is the point. Okay. Resignation clear? This is all about resignation, no other point. This is all about resignation. So in resignation, how many forms came? DIR 11, DIR 12. Both are 30 days only. Okay. Next one, resignation effective date. Date mentioned in the notice or date served, whichever is later. Okay. Resignation is a forceful act or voluntary act? Voluntary act or forceful act? Let's talk about removal. Let's talk about removal. Very one of the simple concept, removal also. After that, remuneration is there. Somewhat large concept. That means you can expect practical questions or case study type of questions from remuneration. Why? Because it will talk about Schedule 5. Schedule 5 Part 1, Part 2, appointment remuneration. So many students are confused about Schedule 5. So nothing to worry. We have clear-cut mechanism to deal with the things. So Monday class, we can discuss remuneration. In today's class, we are going to discuss, apart from resignation, we are now going to discuss what? Removal. Removal is a voluntary act or forceful act? Forceful act. So listen, there is a mechanism. Do you know time gap to conduct AGM? How many days prior notice has to be given to shareholders with respect to calling AGM? 21 clear days. 21 clear days. Clear days means date of notice as well as date of meeting will be excluded. Okay. Not included anna, excluded anna, rendu okate. Okay. So listen, 21 clear days. Who appointed directors? Shareholders. Remember this point. Who are the owners of the company? Kada? So how shareholders appointed, by which resolution? By passing which resolution shareholders appointed directors? By passing simple ordinary resolution. In the same way, so shareholders has the power to appoint you by passing ordinary resolution. Vice versa, the same shareholders has the power to remove you from the company by simply passing ordinary resolution. Few students might think that removal is a big process. We need special resolution. No. To whom company belongs? Obviously, they are the real owners of the company. Who are you? You are just middleman. Directors are middlemen only. They are not the owners of the company. They might become some sort of owners and all, but they are not the solo owners of the company. That is why by simply passing ordinary resolution, shareholders may remove directors. Shareholders may remove directors. So what is the mechanism shareholders has to follow to remove director? Very simple. Shareholders who are holding at least 1% of voting rights. How much? 1% of voting rights. Or shareholders who are holding at least 5 lakhs worth of share capital. So any of these persons can move the resolution to remove a director. Say for example, I have 0.02% voting share in the company, and my shareholding worth is 40,000. Not even close to 50 lakhs, 40,000. Okay, voting share is 0.2%. Okay, am I allowed to make a resolution or to put a proposal with respect to the company regarding removal of a director? No. I need somebody's support. I need somebody's support. ఈ అక్క వచ్చింది. ఈ అక్క వచ్చి, so that akka is having another 0.2% voting power. And she is also holding shares worth of 40,000. 40,000, 40,000, 80,000. 0.2, 0.2, 0.4%. At least how much voting percentage require? 1. So still we need more strength. So we have to motivate. Director ఉన్నాడు చూసావా మంచోడు కాదు. So you have to say something about the director. So whatever you are going to say, you can convince other shareholders saying that we have to remove that director. Okay, so collectively these kind of persons can put a resolution before the company saying that, sir, we don't like that director. We are placing a proposal. Amma, we are not removing the director. Kindly understand. So అక్క నేను కలిపి డైరెక్టర్ని స్పాట్ పెట్టట్లేదు. సో వీఆర్ నాట్ రిమూవింగ్ ద డైరెక్టర్, వీఆర్ జస్ట్ మూవింగ్ ద ప్రపోజల్ టు రిమూవ్ ఏ డైరెక్టర్. వెదర్ దిస్ ప్రపోజల్ ఈస్ గోయింగ్ టు బి సక్సీడ్ ఆర్ నాట్, no one knows. Depends upon you only. Why? Because you are all the members. Depends upon the votes casted by you. If you give approval, director will go out of the company. Otherwise, director will stay in the company only. So in order to put a proposal, 1% voting rights you need, or you have to hold shares worth of 5 lakhs. Then only your voice will be heard. Otherwise, no, not possible. Okay, so okay ma, say for example I am holding 2% voting share, not 0.2, 2% voting share. I have some personal issues with the director. I wish to remove the director. Then what I can do? I will put a proposal. I will send a proposal to the company. Sir, how to send proposal to the company? I have to send the proposal to remove the director at least before 14 days from the general meeting. 14 days from the before how many days? At least. Why? Because 14 days rule has been mentioned. Listen, 21 days notice is there, no? In 21 days notice, what company is doing? Company inviting you and me to attend general meeting. AGM or AGM, whatever it may be. Both are general meetings only. Okay, so company is inviting all of us to participate in the general meeting, AGM or AGM, 21 days notice. So now I got the opportunity. I wish to remove that person. Then within 14 days, within 14 days means from the date of meeting, at least some gap, 14 days gap should be there. Not before 1 day, 2 day, 3 day, 4 day, not allowed. Okay, so I have to communicate to the company with respect to removal of the director. I am holding 2% voting rights, no? So my application will be entertained by the company. That application will be accepted. Then what company has to do? 14 days before I have intimated to the company with respect to the removal of the director, no? Now company has to give intimation with respect to the removal to the so-called director and other members. So it is a responsibility of the company to circulate this information. Sir, okay, circulation of information. Among whom this information should be circulated? First among shareholders, second among the so-called director. So company will intimate to the director saying that some proposals came for your removal. All the best for the meeting. Whether you are going to continue with the company or not depends upon the outcome of the meeting. Be prepared. Company will inform to the director. If director wishes to say anything, that is what we call representation. That is what we call representation. If director wishes to say something to the shareholders, immediately he can write the same and give to the company. If time permits, company will circulate along with this representation also. Sir, time is not permitting, sir. Time is constraint, very close. Then That representation is there, no, written by so-called removing director, that the representation should be read out in the general meeting of the company. Mandatory thing. Why? Because whatever director wish to communicate to shareholders, yes, the company must give a reasonable opportunity to the director to communicate the same. This is a responsibility of the company to facilitate for the activity. After that, voting will be conducted. Ordinary resolution is enough, no? For removing also, ordinary resolution is enough. So if resolution passed, okay, very good, no problem. Resolution passed, that person will go out of the company. Resolution failed. Director proved the strength. Director proved the strength. Obviously, he will continue with the company. This is the thing. And I have already told this point. Whenever change in constitution of directors happened, it is the responsibility of the company to intimate to ROC within 30 days via form DIR 12. Obviously, this rule will be applicable. Are we clear? Tell me the process. First one, proposal should come from members. Members means eligible members. Who are eligible members? Eligible members means at least they hold 1% of voting rights or shares worth 5 lakhs. Then only the application will be entertained. Sir, 5 lakhs means market value, face value. Face value. Not market value. Forget about market value. Market value may be high or low. But to consider face value. Okay. So, if application received, very good. Okay, application received with respect to the removal of the company. Proposal, not application. Proposal received from members with respect to the removal of the director of the company. Very good. Okay. Now, company immediately has to circulate the information among members and so-called director. If director given immediately any written representation for the circulation purposes and all, then company will immediately circulate the information among the members. Say for example, I initiated the proposal, with respect to removal, I initiated the proposal. How do you know? You means you are all members, no? You will stay at different parts of this country. How do you know that there is a proposal which is going on with respect to the company regarding removal of the director? That is why it is a responsibility of the company to circulate the information regarding removal of the director. Along with this circulation, if director gave any written representation, then the written representation also will be circulated along with the notice, along with the information. After that, meeting. Say for example, if circulation of information with respect to written representation is not possible, then opportunity of being heard should be given to the director. That means whatever he wishes to say in the meeting, company has to provide the facility to communicate the same to the members. Then voting will be conducted. Then the fate of the director will be decided. Okay, right. So let's read the material. 169. Now what is 168? Resignation. What is 169? This section deals with the removal of a director by shareholders before the expiry of his term. Of course, removal means before expiry only, no? After expiry, who are you to remove? He will only go. Okay. Who can remove a director? A company may remove a director before the expiry of his term by passing ordinary resolution in a general meeting. Simple, so by simply passing a ordinary resolution, members can remove the director. However, following directors cannot be removed. One is director appointed by tribunal. That means director appointed by court. Director appointed by tribunal. So if any director is being appointed by tribunal, it is in the best interest of the company only. So you don't have any powers to remove such kind of directors. And a director appointed under the proportional representation. Sir, what is proportional representation? It is not there in your syllabus. I will tell you at a later point of time. Not a later point of time, Monday we can discuss. Or if time permits, I will tell you now only. Why? Because it is not there in your syllabus. It is waste of time to discuss. But I'll tell you. What is meant by proportional representation? చెప్పేస్తాను చూడండి. Proportional representation simple ma. Say for example 1000 shares are there in the company. That means 1000 votes are మా ఏంటమ్మా 1 share 1 vote కాదా? 1 equity share means one. How many votes? 1 equity share means 1 vote. If you hold 10 shares, you have 10 votes. If you hold 100 shares, you will have 100 votes. 1 share is equal to 1 vote. తెలుసా తెలీదా? ఫస్ట్ థింగ్ అది చెప్పండి. 1 share is equal to 1 vote. Say for example, listen. Company has 1000 shares. Company has 1000 shares. That means how many votes ma? 1000 votes. Company is planning to appoint 10 directors. How many directors ma? 10 directors. Company is planning to appoint 10 directors to the board of the company. Okay, very good. Normally, in traditional scenario, in normal voting, say for example, a public company. I have already told you that for each and every appointment of director, one resolution will be passed. That means for each and every appointment, voting should be conducted. In case of private company, all resolutions, all appointments in one resolution, that is a different thing. Okay, the Bilibitra company. So talk about public company. So listen, out of 1000 votes, persons who are holding 600 votes, form a cartel together or form a group together. Then what will happen? Listen. Say for example, we are companies considering X appointment, X as a director appointment. All these 600 votes will be cashed for that X. Remaining 400 votes are there. No, of course 400 votes are there, will be cashed to X. Sorry, to another person other than X. Okay. For X, how many votes cashed ma? 600 votes. For other person, 400 votes maximum. Who will win? Obviously 600 votes cashed to Mr. X out of 1000. That means majority. Ordinary resolution. X appointed to the board. Now, company is considering Y and opposite person to Y. This group supports Y with 600 votes. That minority group 400 votes supports other person who is acting as, who is contesting against Y. Again same scenario will be repeated. Y will be appointed. Z is coming to election and opposite contestant of Z is also coming to election. Again this 600 votes group is there. No, these guys will support Z. That 400 votes group will support other contestant who is contesting against Z. Obviously Z will be appointed. Like this, 10 out of 10 directors. That means 10 out of 10 directors will be in the control of majority. Group which is holding 600 votes. A group which is holding how many votes? 600 votes. Persons who are holding 600 votes are shareholders only, and persons who are holding 400 votes also become shareholders. Will shareholders will debenture holders avutara? Everybody are shareholders only. But listen, one kind of group dynamics are happening with the company, and there is a rivalry existing between this 600 group, 400 group. Obviously, even though 400 votes are there for this group, the company administration A to Z will be dominated by this 600 group only. 10 out of 10 directors are elected to the board with whose support? Of course 600 votes support. Then on whose favor they will accustomed to act as directors? 600 votes. Of course, even though 400 group is there, no one will listen to their voice. oppression and mismanagement, minority. Okay, so there is a possibility, yes, 101% in reality or in practical scenarios also, there is a possibility that these kind of things will happen. Of course, on caste equations, Andhra side caste equation, or no, Telangana side region equations, manoda baitoda. అక్కడ అంతే ఇక్కడ అంతే పెద్ద పతివ్రతలు ఎవరు లేరులేండి. So whatever these kind of equations, so shareholders will be distinguished depends upon this group dynamics. Then these 400 votes, shareholders who are holding these 400 votes, their voice become useless. No one is there to hear their voice. What is their representation in the board? How many directors will listen to their words? No one. Why? Because 10 out of 10 directors will listen to 600 group only. Isn't it unfair? That is why there is a mechanism. Appointment by proportional representation. Appointment by proportional representation. Sir, what is this proportional representation? Listen. What is this proportional representation? Amma? Okay. How many shares are there? 1000 shares are there. That means how many votes? 2000 votes, huh? How many votes? 1000 votes. Very good. How many directors you are planning to appoint to your company? Very good. 10 directors you are planning to appoint to your company. Very good. 10 directors you are planning to appoint. Now, 2 groups are there in the company, right? Okay, very good. Yes, group mechanism is there. You can't avoid this kind of group mechanism. Then, listen. Votes will be multiplied by number of appointments. Votes will be multiplied by number of appointments. Amma, listen. I'll tell you in a detailed way. Amma, how many shares are there? 1000 shares. That means 1000 votes. How many groups are there? 2 groups. 600 group, 400 group. 600 votes group, 400 votes group. How many directors company is planning to appoint? 10 directors. Then what will happen? You have to multiply number of votes with the number of appointments. Number of votes 1000, number of appointments 10. 1000 into 10. So technically you are having 10,000 votes. Technically you are having how many votes? 10,000. Are you following? It's not a rocket science, ma. Simple calculation. 10 into 1000, 10,000 votes. Simple. Listen, how many groups are there? 600 group. Now tell me, for 600 group, how many votes are there? 6,000 votes. For 400 group, 4,000 votes. Now, proportional representation mechanism will be applicable. So, being these guys are having 40% strength, how much strength? 40% strength. 40% directors can be appointed according to their wish and will. How many directors companies are considering to appoint? 10. 10 into 40%. Now, this 400 group will appoint 4 directors in the composition. This 600 group will appoint 6 members in the composition. Sir, even then they are forming majority. Ore, అంతకుముందు అది కూడా లేదు కదరా, ఒక్క డైరెక్టర్ కూడా నీ మాట వినలేదు. No one is listening to your words previously. You are unable to appoint even 1 director, but now you are having 4 directors. Something is better than nothing, no? That is the case. This is what we call proportional representation. Ma, listen. These 4 directors are there, no? With whose support they elected to the board? 400 votes. Let's call them with the name called minority. Are we clear? Is it comfortable? Are you following? With whose support they are elected to the board of the company, ma? Minority support, they elected to the board of the company. Obviously, in order to protect whose interest they will accustomed to act? Minority interest only. So being, listen, that means directors appointed by proportional representation are there to represent minorities' rights. That is why it is not possible for them to remove. Even though shareholders are fixed to remove this kind of directors, law is not providing such kind of gateway to remove directors appointed by proportional representation. Why? Because they must be there in the board of the company to act as a voice for minority shareholders. Minority shareholders. Are we clear? Listen, back to the topic. Now, what we are discussing? We are discussing the removal. It is possible to remove the board of directors of the company, but two directors you are unable to remove. First one is director appointed by the tribunal, and the second one is director appointed under the. Now, is it giving any clarity? Why directors? Why members are unable to remove directors appointed by proportional representation? Means they are acting as voice of minority, and you are killing that voice by removing. By removing, you are killing that voice. That is why law is not providing such kind of facility to provide removal of directors who elected by proportionate representation. Is it clear? Adhangalada? Shall I repeat once again? No? Very good. So if you are comfortable, we can move forward. Okay. So first of all, we are talking about removal. Directors can be removed by members by simply passing ordinary resolution. In order to put the but two directors are not possible to remove by shareholders. Who are the two directors? Managing director, whole-time director. MD, WTD, yeah? First one is what? Directors appointed by tribunal. That means court. If any directors has been appointed by the order of the tribunal or court, then it is not possible for the members to remove them. Second one, directors appointed by proportional representation. They are representing the voice of minority. That is why it is not possible for members to remove the directors from the board of the company. Next one, procedure for removal of directors. Sir, what is the procedure which we need to follow to remove the director? First one, special notice. Special notice must be initiated from members to company. The members must hold at least 1% of total voting power or shares on which aggregate sum of 5 lakhs been paid up. Must give special notice to the company at least 14 days before the meeting. Sir, why 14 days? Company has to, there must be some time allowable for the company to circulate the information, right? That is why 14 days time. If meeting is scheduled tomorrow, today evening you came and giving notice for the resignation, so the removal of the director, it is not the correct way. You have to approach the company at least 14 days before the meeting. Notice to director. Then the company must immediately send a copy of the notice to the concerned director. Right to be heard. The concerned director has a right to make written representation and request circulation of the same to members. If not circulated, the director may request for the representation to be read in the meeting. Did we completed this discussion? Low battery. Low battery. Next one. So general meeting. The company must call a general meeting, either AGM or EGM, and pass ordinary resolution to remove the directors. You very well know this point. Filing with ROC. Whenever change happened with respect to the constitution of the board of directors, it is the responsibility of the company to intimate the same to ROC by a via filing the form dir3 within 45 days. 45 days. 30, 45 both are same only. Yes or no? No. Yes. So no yes. Director's rights during removal. Amma, what are the rights available for the so-called outgoing directors, director who are going out of the company? What are the directors? What are the rights available? They have right to receive a copy of the special notice. Special notice members initiated. No, first that one. Right to make written representation. Third one, right to attend the meeting and be heard. Whatever the points he wished to escalate. నేను మీ కంపెనీ కోసం ఇంత కష్టపడ్డాను, నన్నే బయట పంపించేస్తారా ద్రోహుల్లారా, ఏదో ఏదో ఎమోషనల్గా 4-5 డైలాగులు చెప్పుకోవడానికి అవకాశం ఇవ్వాలి. అఫ్కోర్స్ ఇదే జరుగుతుంది రియాలిటీలో. అంతకని నేను జరుగుద్దమ్మా, వాళ్ళని మీ చుట్టాలా, పర్సనల్ ఇష్యూస్ అని చెప్తారా మీకు? ఒకప్పుడు మా ఆవిడ నాకు కూడా ఇలాగే డైవర్స్ ఇచ్చింది, తర్వాత బాధపడుతుంది, మీరు కూడా నాకు డైవర్స్ ఇస్తున్నారు, బాధపడతారు, ఇది చెప్తారా? ఎమోషనల్లీ హీ విల్ ట్రై టు గ్యాదర్ ద సపోర్ట్ ఫ్రమ్ ద మెంబర్స్. Why? Because voting is there, no? He has to pass that voting. So that is why, by hook or crook, director wish to grab the attention of the members to pass the, to set aside this so-called special notice and resolution. Whether he will succeed or not depends upon the acting done before the members and all. Okay? No one knows. Next one, comparison table, resignation and removal. What is the comparison table? Resignation initiated by director himself, whereas removal by governing section 168. Need for board resolution. No, you are going out of the company by simply serving a resignation. Why board resolution is needed? But in case of removal, board resolution is needed. Why? Because call for meeting. Meeting should be there, no? Resolution where they will pass, in meeting only, no? So, resolution needed. Filing with ROC, yes, DIR12, DIR12. But in case of resignation, DIR11 is also there. Right to be heard, not applicable. Why? Because he is not listening to anyone. He is serving a notice and going out of the company. Whereas he has the obligation to gather the support from the members. That is why, yes, right to be heard is there. Liabilities post event, that is after exit, continues for acts done during the tenure, not afterwards. Whereas this case also continues for acts done during tenure. Mandatory in OPC. Yes, in case of OPC, if only one director is there, then it is a responsibility of the person who is going out of director, who is going out of the company, to appoint another person as director. Then only you should go out of the company. This is not practically possible. Okay. Remuneration of directors, which we are going to discuss on Monday. Remuneration is a very big thing, I think 2 sessions it will take to properly communicate the remuneration topics and all. So far as concerned, are we clear with the discussion? So, resignation, removal. So, these 2 topics we have completed in this session. Okay. Right, remuneration we can complete, we can start on Monday's session. Okay, right, happy weekend. That's all for today's session. Exam unda repu emena em leduga.